12 guns. 12 very different reasons they could become harder to buy, transfer, or configure in 2027. Some are caught by stocks, magazines, or trigger parts, while others are being challenged directly in court, and number 1 could reshape the entire list. Number 12. The Ruger Mini 14 Ranch Rifle Sturm. Ruger introduced the Mini 14 in 1974, a scaled-down cousin of the M14 chambered in .223. For half a century, it has been the semi-automatic rifle that almost nobody argued about. Wood stock, blued steel, no pistol grip. It looks like something leaning against a fence post on a Wyoming cattle ranch. And that appearance is precisely why it walked untouched through the 1994 federal ban that named so many of its relatives. Connecticut's statute still singles out only one version of it, the Mini 14/5F with the folding stock. Colorado landed in the same place. When state regulators published the exemption list under Senate Bill 25003, the Mini 14 Ranch Rifle and the Mini 30 both made the protected column, but only as they are currently configured. Fit that same rifle with a collapsible stock and the shelter evaporates. Think about what that means at the gun counter. Same barrel, same gas system, same cartridge, same rate of fire. Nothing mechanical changed at all. The furniture changed. And heading into 2027, furniture is still what most of these statutes are actually looking at. That logic gets stranger when the rifle in question is a piece of American military heritage. Number 11. The Springfield Armory M1A. The M1A is the civilian descendant of the M14, the rifle American soldiers carried before the black rifle era began. Springfield Armory brought it to the commercial market in 1974, chambered in .308 Winchester, walnut stocked, and built like a bridge girder. Competitive shooters at Camp Perry have won matches with it for decades. Colorado's exemption list includes the M1A standard issue as it is configured. But the M1A is not one rifle, it is a family. Shorter barreled variants with different furniture and muzzle devices did not receive the same protection. And once a rifle falls outside a named carve-out, it lands back inside the general rule covering any semi-automatic rifle that accepts a detachable magazine. Virginia's Senate Bill 749, signed in May of 2026, works on a one-feature test. A semi-automatic centerfire rifle crosses the line if it has a single listed characteristic, including a folding or thumbhole stock, a second hand grip, or a threaded barrel capable of accepting a muzzle brake or a flash suppressor. A woodstock Target M1A clears that test. Its shorter threaded stablemate does not. 2 rifles, one design, one production line in Geneseo, Illinois. 2 very different legal futures. Number 10. The Smith & Wesson M&P 15-22. This one surprises people. The M&P 15-22 is a .22 long rifle plinker. It is the rifle parents buy so a 12-year-old can learn trigger control without recoil or expense. It shoots the same cartridge as a bolt-action squirrel gun. Colorado's law exempts rimfire firearms of .22 caliber or smaller, which sounds like a clean carve-out until you read the second half of the sentence. The exemption disappears if the firearm has a separate upper and lower receiver. That clause was written to catch AR pattern .22s, and it does exactly that. A traditional Ruger 10-22 with its one-piece receiver stays outside the law. An AR-style .22 does not. When the Colorado Department of Revenue published its guidance document, it ran to roughly 900 makes and models across 152 pages. Ray Elliott, president of the Colorado State Shooting Association, argued publicly that lawmakers had promised ordinary firearms would be untouched, and that the agency's own list proved otherwise. Since August 1st of 2026, buying one of these rimfire trainers in Colorado means a sheriff-issued eligibility card, a background check, and an in-person safety course with a live-fire component, a .22 rifle for teaching kids, sitting behind the same paperwork wall as an AK. That is the shape of the modern gun law. Number 9. The Kalashnikov USA KS-12 and the magazine-fed shotgun family walk into a shop and look at the shotgun rack. A Mossberg 500 pump, a Remington 870, a Beretta 1301, a Benelli M4. All of them feed from a tube running under the barrel. None of them appear on Colorado's covered list because a tube is not a detachable magazine. Now look one shelf over at a Saiga pattern 12 gauge, a Turkish MKA 1919, or an AR-styled box magazine shotgun. Those are covered, so are bullpup shotguns. Genuine Russian Saiga imports ended in 2014 under sanctions, so the American market moved to domestic builders like Kalashnikov USA, whose KS-12 fills that space today. Rhode Island drew its line differently. Its Assault Weapons Ban Act, effective July 1st of 2026, defines a prohibited firearm to include semi-automatic shotguns with fixed magazines holding more than 6 rounds, alongside semi-automatic rifles with fixed magazines over 10. Different test, different guns caught. There is history here too. Connecticut's original list named the Street Sweeper and the Striker 12 revolving cylinder shotguns from South Africa, plus the Franchi Spas 12 and the Benelli M1 Super 90. 30 years later, legislatures are still writing shotgun rules around whether ammunition sits in a tube or a box. Number 8. The Barrett M82A1. Ronnie Barrett was a photographer in Tennessee with no engineering degree when he sketched a shoulder-fired .50 caliber rifle at his kitchen table in the early 80s. The M82 went into production in 1982 and became the Light 50, a recoil-operated rifle firing the same cartridge Browning designed for machine guns after the First World War. It also became the most reliable headline in American gun legislation. Connecticut's statute names it directly as the Barrett Light 50 Model 82A1. When the Fourth Circuit described Maryland's ban, it framed the question around military-style weapons including the AR-15, the AK-47, and the Barrett 50 caliber rifle. California banned 50 BMG rifles outright back in 2004. The practical reality is worth stating plainly. A Barrett costs as much as a used truck, weighs around 30 pounds, and appears in crime statistics almost never. It survives on ban lists because it is the single most visually intimidating rifle a legislator can hold up at a press conference. That is a defensible political instinct and a weak empirical one, and both things can be true at the same time. Number 7. The Century Arms WSR-10. If the Barrett is the rifle nobody owns, the WSR-10 is the rifle everybody can afford. Built at the Cougar Arms plant in Romania and imported through Century Arms in Vermont, it has been the entry-level Kalashnikov for American shooters for a generation. Stamped receiver, wood furniture, 7.62 by 39. Connecticut lists it by name. Colorado's rifle category covers it. Rhode Island's feature test covers it. Virginia's law covers it. And this is where the courts stopped agreeing with each other. In July of 2026, 3 federal appeals courts ruled on nearly the same question within 3 weeks. The 7th Circuit upheld Illinois. The 1st Circuit upheld Massachusetts in Recchia versus Campbell. And the full 3rd Circuit struck down New Jersey's ban 10-5 with the majority opinion written by Judge Ariana Freeman, a Biden appointee, holding that rifles in common use today cannot be prohibited. 3 courts, 3 outcomes, 1 rifle. New Jersey's Attorney General called the ruling legally incorrect and noted every other circuit had gone the other way. The NRA called it a historic victory. Both statements were accurate descriptions of the same afternoon. Number 6. The Magnum Research Desert Eagle. Here is where a law written for rifles reached out and grabbed a handgun almost nobody expected. Colorado's statute covers semi-automatic rifles and shotguns with detachable magazines, and then adds 1 narrow handgun category: gas-operated semi-automatic handguns with detachable magazines. Nearly every pistol in America is recoil-operated. A Glock, a Smith & Wesson M&P, a SIG P320, a 1911. Colorado lawmakers said openly that recoil-operated designs make up well over 90% of the handgun market and would not be affected. They were right about the percentage. But the Desert Eagle is the famous exception. Designed in the early 80s and long associated with Israel military industries, it uses a gas system borrowed from rifle engineering to tame the recoil of cartridges like the .50 Action Express. That choice made it a movie prop legend and, 40 years later, made it one of the very few handguns to walk straight into a permit regime built for AR-15s. AR and AK pattern pistols land there too, along with the B&T APC family. The engineering decision came first by 4 decades. The legal consequence arrived in 2026. Number 5. The Steyr AUG A3M1. Austria adopted the Steyr AUG as the STG-77 in 1977, and it changed what a rifle could look like. Bullpup layout with the action behind the trigger, a polymer housing when polymer was still exotic, an integrated optic, and a quick-change barrel. It looked like science fiction and shot like a service rifle. American legislatures noticed the silhouette immediately. Connecticut names the Steyr AUG in its enumerated model list, sitting alongside the FN and the FN-FNC. New York, New Jersey, and California list bullpups as well, and Colorado's shotgun category expressly reaches bullpup designs. The AUG does not hit harder than a wood-stocked hunting rifle in the same chambering. It is a different arrangement of the same parts. But arrangement is exactly what these statutes measure, and a rifle that looks unlike anything in a 1950s sporting goods catalog has never fared well on a list. Number 4. The SIG Sauer P320. Politics has nothing to do with this one. It is an engineering dispute, and it may be the most consequential entry here. SIG won the Army's modular handgun system contract in 2017. The P320 became the M17 and the M18, replacing the Barrett M9, and civilian sales followed at enormous scale. Its serialized fire control unit was a genuinely clever idea, letting one registered component move between frames and slides. Then came the discharge reports. More than 200 documented complaints of uncommanded discharges, more than 100 lawsuits, 2,024 jury verdicts against SIG in Georgia and Philadelphia. The Washington State Criminal Justice Training Commission barred the pistol from its training facilities. Immigration and Customs Enforcement dropped it in July of 2025, directing a switch to Glock. Air Force Global Strike Command paused the M18. Chicago began a phase-out. Denver, Milwaukee, and Houston moved on. In October of 2025, New Jersey became the first state to sue SIG Sauer directly, seeking a state sales ban and a mandatory recall. SIG's position has never wavered. The company says the P320 cannot fire without the trigger being moved rearward, points to extensive testing, has issued no recall, and has won cases too. A federal jury in Cole versus SIG Sauer found unanimously that the pistol has no defect, and in July of 2026, the 8th Circuit ordered a class action dismissed in its entirety. New Hampshire passed a liability shield law in 2025 that SIG had lobbied for. So the P320 could become the first modern American handgun restricted not by politics but by a product liability finding, or it could be fully vindicated. As of today, both roads are still open. Number 3. The AR-15 with a forced reset trigger installed. The rifle here is not the variable. The trigger is rare breed triggers released the FRT-15 in late 2020. The ATF classified it as a machine gun, seized units, and spent 4 years in court. In July of 2024, Judge Reed O'Connor in the Northern District of Texas vacated that classification as beyond the agency's authority, leaning on the Supreme Court's reasoning in Garland versus Cargill, the bump stock case. In May of 2025, the Justice Department settled, dropped its appeal, and agreed to return seized devices with owner requests due by the end of that September. Federally, the question closed. At the state level, it did not. 15 states plus the District of Columbia prohibit these devices under rapid-fire or trigger activator statutes, including California, Illinois, New York, New Jersey, Maryland, Massachusetts, Oregon, and Washington. Colorado is the sharpest case. Senate Bill 25-003 classified rapid-fire devices as dangerous weapons the day the governor signed it in April of 2025. Possession is a Class 5 felony there. With no grandfather clause and no permit pathway of any kind, 16 states then sued the federal government over the settlement. California's Attorney General later announced that the ATF had agreed not to return seized devices into states where they are unlawful, offering owners disposal options instead. Same rifle, same owner, same serial number. One small component decides which side of a felony line it sits on. Number 2. The Glock 19. Gaston Glock was making curtain rods and field knives in Austria when he designed the Glock 17 in 1982. The compact Glock 19 that followed became the most widely carried duty and concealed carry pistol in the United States. It is the pistol on the hip of a substantial share of American police officers, including many NYPD officers. Beginning in 2025, 4 states wrote laws that never say the word Glock. They define a convertible pistol by an internal component, the cruciform trigger bar, and prohibit the sale of anything using that design. California's AB 1127 came first, taking effect July 1st of 2026. Maryland's Senate Bill 334 was signed by Governor Wes Moore in May of 2026. Connecticut's Public Act 26-41, signed by Governor Ned Lamont, makes selling or importing one a Class D felony as of October 1st. New York buried its version inside the state budget bill that Governor Kathy Hochul signed on May 27th of 2026. And New York is where 2027 actually bites. Under that law, a dealer or gunsmith who sells or transfers a convertible pistol on or after May 31st, 2027 commits a Class D felony. State police are tasked with determining which models qualify. Number 1. The Colt AR-15. Eugene Stoner designed the AR-15 at Armalite in the late 1950s. Armalite sold the design to Colt in 1959, and Colt put a civilian version on the market in 1964. Connecticut's statute still lists it by its original commercial names, the Colt AR-15 and the Sporter. On June 30th of 2026, the Supreme Court granted review in 2 cases, Viramontes v. Cook County out of the 7th Circuit and Grant v. Higgins out of the 2nd Circuit. They were consolidated for a single argument in the term that began in October. A decision is expected by the end of June 2027. The setup was visible a year earlier. When the court declined the Maryland case, Justice Thomas wrote that he would not wait to decide whether government can ban the most popular rifle in America. Justice Kavanaugh, while voting not to hear it then, predicted the court would address the AR-15 issue in the next term or 2. That prediction came true almost exactly on schedule. If the challengers win, roughly a dozen state bans are in immediate jeopardy, including those in California, New York, New Jersey, Massachusetts, and Washington. If the states win, the feature test model spreads. Legal analysts on the gun rights side, including Amy Swearer, have cautioned that even a win is unlikely to end the fight.